everyone. Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm Attorney John Redmann.
And hello, everyone. I'm Shauna Sanford. Welcome to the show. If you or someone you know has filed a claim for harm caused by the BP oil spill, then you are probably very familiar with the latest attempt by the oil giant contesting the amount of money being paid to victims. BP claims too many fraudulent claims are being filed and awarded. Specifically, the oil company says the claims administrator is misinterpreting how the payments should be made. BP is appealing a decision by U.S. District Judge Carl Barbier, who's already ruled 3 times now that the claims administrator does not have to adopt BP's interpretation of the settlement deal.
Our guest today is the man in charge of handling those payments, Attorney Patrick Juneau. He will join us in a few moments to explain how the claims process works, the settlement, and what could happen if BP is successful on appeal. We're very excited to have him here with us.
John, we really are excited to have Attorney Juneau here, but before we bring him on, let me ask you, because your office, you're handling some of the claims by some of the businesses that were damaged during the spill. What could potentially happen if BP is successul?
Well, that is a gigantic question mark, and frankly, it depends on so many factors. But I think the most important thing is that the claims are currently being paid. They're being paid, and if you have a business claim, or you think you might have a business claim, it's so important that you continue on with that process. Even if you have yet to file a claim, you can find out if you have a business claim and talk to your attorneys about that. There are a lot of attorneys out there handling those claims, and the court has said that the claims will proceed until further notice.
Yeah, well, it's a big topic, and we certainly have the right person here today to talk to us about that. Coming up, claims administrator for the Deepwater Horizon Settlement Center, Attorney Patrick Juneau, will join us in just a few moments to talk about the controversy surrounding the claims and what you need to know if you have filed a claim or you need to file one. Stay with us. We'll be back.
My life is full of statistics. Thing is, I could have dropped out of school and become one myself, but I didn't, because I had people that believed in me. Here's another statistic. 7,000 students drop out every school day. That's 1 every 26 seconds. It's time that students know that we believe in them.
Inspire a student and share your message of support at boostup.org.
Hello, everybody, and welcome back. Well, our hot topic today is the BP settlement for damages caused by the massive Gulf oil spill in 2010 and the fight BP is waging against the way the claims are being handled. Our guest today is the claims administrator for the settlement, Attorney Patrick Juneau.
Attorney Juneau has an incredible list of accomplishments. He has served as a mediator in over 4,000 cases. He is a graduate of LSU Law School and a former member of the Louisiana Defense Council. And he was part of the group that drafted the new state constitution. It is a great pleasure to have Mr. Juneau on the program today. Mr. Juneau, we're grateful to you for your time. It's really an honor to have you on the show.
Delighted to be here.
And I must say, this is an exclusive. John Redmann, Power of Attorney, is hosting you on the show. And it's unfortunate that you have not yet had an opportunity to really come on the TV show as the man at the top of the pyramid to discuss what do people need to know about the claims process. And we're going to cover it today. Who's eligible? What do you need to know to make a claim? What does your office do with the claims? And what is your job? So let's jump right in, shall we?
Let's have at it.
Tell us what is the BP claims agreement, settlement agreement?
Well, before I was ever involved in this case, negotiations had went on, I think, in excess of a year. Literally hundreds of people were involved from the plaintiff's standpoint, from BP's standpoint, negotiated months and days and hours over this agreement, resulting in an over 1,000-page document that has more detail than we are at liberty to discuss today. But it was a product of hours and hours and hours of intense negotiation between the parties. I was not a participant in that. I didn't draft the agreement. I didn't have any input into the formulation of the agreement. I'm after the fact, after the agreement is formulated, then I become involved through court appointment. I serve at the pleasure of the court. I don't represent the plaintiffs. I don't represent BP. My job is to carry out the duties assigned to me by the court, and that is to implement this settlement agreement.
And I think that's very important to point out, that while you are in charge of implementing this settlement, you are not working for BP, although this is the BP settlement.
I don't work for either side.
For either side. Help us to understand the settlement that you're in charge of and the prior settlement that was headed up by Ken Feinberg. Are there big differences?
Oh, there are huge differences. It's like talking about two different universes. Under the prior program, the Gulf Coast Claim Facility, Mr. Feinberg was designated to be in charge of that. That was not under court supervision. That program was developed and formulated. It was a very difficult task, I might add, and to his credit, and should be given credit for that. They implemented that program. They formulated the criteria and the requirements for eligibility and what you had to produce and not produce.
They being the parties, BP and the plaintiff?
Mr. Feinberg developed that through the Gulf Coast Claim Facility. That's not true here.
Okay.
This case, we have over 1,000 pages of documents, about that high, of detailed, meticulous requirements of what is required to be an eligible claimant. And if you meet those requirements, we pay those claims. You don't meet those requirements, we don't pay those claims.
Well, we're actually going to get into that, and I'm not trying to jump the gun here,
Sure.
but just to kind of, let's see if I'm keeping up so far. Both parties, BP, with literally hundreds of lawyers is what I understand, they negotiated a settlement with a bunch of lawyers who represent the interests of everybody who might have a claim. That's people with businesses who might have lost income, and individuals who maybe were affected financially because of the oil spill from the Deepwater horizon. They got together. They, over a period of months, hashed out a settlement agreement. They got approval. They got approval in the federal court.
Yes, sir.
And as part of that settlement agreement, they had sort of like a special master, they call it in federal court, except in your case they call it a claims administrator. And you are the claims administrator in charge, holding the purse strings of all that money that BP understood would be paid to people who met the requirements to get paid a claim, correct?
That is absolutely correct.
All right. And so, and since that time, and this happened some months back, right? Earlier this year?
Yes,
April?
This program actually started on June 4 of last year.
2012.
Of 24, okay. And so why don't you walk us through, just give us, we got to do broad brush strokes, and let's try and do it in plain English for people who didn't get to go to law school or graduate school. Well, how do you qualify? Who does the settlement agreement cover?
This is a unique settlement. To the credit of both sides, it took hours and hours to negotiate this thing. But what they did was is they formed what they call a class, and you provide the parameters of the boundaries of what this class is.
If you're in the class, you may get paid. If you're not in the class, you definitely don't get paid.
You got it in spades.
Thank you.
So what occurred is in the negotiations, obviously, and I was not there, they determined, BP and the plaintiffs said that the entire state of Louisiana, the entire state of Mississippi, the entire state of Alabama, and a portion of Florida all the way down to the Key West, and a portion of the state of Texas, that if you fell within those parameters of those geographical boundaries, that you met the threshold test of eligibility. So in other words, it wasn't a question of whether you were above I-10, for example. If you were in the state of Louisiana, you met the threshold test. Then it went on to get very specific requirements. An object was to give objective testing. That was the whole object of this exercise, was to give tests that could be applied so that beyond being in those boundaries, that if you met the documentary requirements and the financial requirements that are set forth, then you want eligible claimant. The document is very, very specific of what you have to provide in terms of documentation. For example, a business claim, monthly statements, tax records, and things of that nature. But the uniqueness of the case is reflected by the fact of these geographical boundaries that we start with. For example, a person in Monroe, Louisiana would be within the geographical boundaries as defined by the settlement agreement, as agreed to by the parties, and as approved by Judge Barbier in the ruling in November.
He's the federal court judge.
Absolutely.
Where
That's
the lawsuit
interesting, yes.
was otherwise pending, right?
He's the judge that has jurisdiction over this case.
Okay. So, I'm sorry, go ahead.
So, going back to that 1,000-page document, it's stipulated in there who is eligible and how these claims are to be processed. And it sounds like you're saying it's pretty black and white, but it seems that there is an issue here over the interpretation of the way you're interpreting it, the way BP is interpreting it. So, help us to understand what's going on there.
There's some serious issues that are pending now, and I'll address that if you want during the course of this discussion. Before the Fifth Circuit Court of Appeals, I'm not at liberty and could not and would not comment on an issue that's pending before the court. I've religiously not done that.
Right.
And I don't want to do that today.
And we're not going to ask you to do that.
And I know you're not going to.
No.
Thank you very much.
Of course.
But with that aside, the real issue on the table, well, there's two kind of issues on the table. One is there are questions about causation. What cause is this has to be related directly to the spill. I say that the agreement addresses that. We addressed hypothetical questions of the parties which addressed that. We got all that cleared up earlier, but there still seems to be some dispute about this.
Yeah, let's digress for a moment and talk about that. And what most people understand in any sort of a lawsuit is the person who makes a claim, in most lawsuits, Louisiana, Texas, Alabama, Florida, you have to show causation. Two parts of a case. Causation, damages. Causation means that guy ran the red light. It's his fault. He caused the harm.
Right.
And then after you show causation, that you caused the harm, then you argue about how much damages resulted. I got medical bills, I have pain and suffering, and then you put a dollar value on that. This is very unique in this case because according to the terms of the settlement, the way it's been enforced all this time, and according to what most people say when they read the settlement agreement, BP agreed, for good reasons we can go into, at least I'll go into it, BP said that we won't argue about causation. We will not argue about causation. If you live in that geographic area that you just defined, if you live in that area and you can show that you had a decrease in income, for instance, let's say business claims. In full disclosure, my law office handles claims against BP, so take it with a grain of salt. If you can show a decrease in finances per the special way it's outlined in the settlement agreement, and you fit in the class, then BP has to pay the money, as long as your office agrees that the I's are dotted and the T's are crossed. You don't have to prove causation. You don't have to prove it's because of the oil spill. Did I lay that out accurately as far as your understanding of what at least what the plaintiffs are saying?
Pretty much on target. Let me give you an example of exactly what you're talking about. Early on in this stage, that's as I understood the settlement agreement as written. But for clarification purposes, way early in the process, we put a hypothetical to the parties, my office did, to make sure we had it right. And the hypothetical was there's 3 accountants who live in middle region of the state. The 3, one of the accountants has a heart attack. So he's obviously not working during this dip period.
Because he's in the hospital or he's
in the
laid
hospital,
up in bed.
And I'm looking at the medical records and I know that. And then I see he comes back at the end of that 6-month period and he's working again and the income goes back up. So according to the financial test that's laid out in this agreement, he meets the financial test. But I know, looking at that record, it's not directly related to that oil spill because it speaks for itself. So our question was, we raised it because we wanted to confirm that we had it right. We said, under that given circumstance, are we to apply, is this strictly a objective test, and we're not to look at the alternative cause? And the answer was, from the parties, that is correct.
So BP's answer was, before the settlement agreement was finalized.
Well, this was after it was finalized. That came after.
But BP at that time
confirm exactly
said, right, we already understood as part of the deal, we're not looking at causation, so even if the guy had a heart attack, and that's why he has less income.
And I'm going to have to let you answer that when we come back, because we do have to take a quick break, okay? So We'll get to that and more questions. Stay tuned. We're going to get your questions for our guests when we return. We'll be right back after this break.
Never forget our best teachers, the ones who do so much more than teach. They inspire and insist we bring our best in everything we do. We find those mentors in our Catholic schools. It's why Catholic school graduates consistently go on to college, land better jobs, embrace faith, and lead. Louisiana Catholic Schools, in a class of their own.
And welcome back. Our guest today is attorney Patrick Juneau. He's the claims administrator for the Deepwater Horizon Claims Center. We've learned so much about how the BP claims process works, and we appreciate that you are very interested in this topic as well. So we are going to get to some of your questions. I wanted to ask you, though, did you want to finish your thought there?
I told you there were two important issues. I discussed the causation issue with you. We've been through that to the court. That's already been addressed to the court and to the parties. The second issue, though, is the issue of the compensation piece, is how in these business economic claims you evaluate those claims insofar as eligibility. That's the big issue that's on the table before the Fifth Circuit Court of Appeals. That's an issue I can't comment about other than tell you that I interpreted the agreement in a certain fashion to apply the applicable periods of time that I thought that the agreement told me, instructed me to do. That went to the United States District Judge, Judge Barbier. In a written opinion, he sustained that position. That's the issue that is now before the Fifth Circuit Court of Appeals. It has to do with revenue and expenses. BP has appealed that, and they have a perfect right to appeal that. It's like any other issue surfacing anywhere. You agree or disagree, and you appeal. That's the issue that's up before the Fifth Circuit now, and I'm interested in obviously in the result of that opinion. BP is, and so is the plaintiffs. But however the court instructs us to follow that rule, or whatever the court instructions are, that's exactly what we will do.
What you're going to do, and that ruling could come at any moment.
We expected it.
Let me just bookend that real quick, because a very important piece of the puzzle that why would BP agree to a settlement where nobody's got to prove causation? The understanding was BP had the risk of having a judgment against them that involved punitive damages, which could be a multiple. It could multiply the size of everybody's award against BP. And so it was a deal they cut, according to my informed sources. In other words, they don't have to worry about punitive damages, but they don't complain about whether or not somebody definitely has damages caused by the oil spill or not. And that accountant who had a heart attack, he's just one of the few that also gets included in the net that gets to make a claim if his heart attack is the real reason. Is that accurate with your understanding as well?
That's I wouldn't have participated in the negotiations, but those were the issues that were going on at the time. It's not for me to make that decision. What is my job, and which I have done and which I will continue to do, is to independently enforce this agreement as it's written. And that's what I'm attempting to do here.
Okay, so let's get to our viewer questions. We've got a question from Wayne. Do I need an attorney to file a business claim? And I guess the other question to that is, can people still file business claims?
Yes, under the terms of this agreement, they have until April 22, 2014 to file, for example, a business claim. That's specified in the settlement agreement. Okay. So we got a way to go here.
We do have a way to go. Now, does a person need an attorney to file a business claim?
No, you don't need an attorney. You can, you can do it online. You can do it by hard copy. Several ways. We have claim centers, 19 of them, stretching from Key West all the way to south of Beaumont, Texas, to receive the claim. It's a relatively easy thing to do, and the requirements are set out in the on the website.
Now, what do you tell people? What sort of documentation do they need when they do start this process?
Well, that's a little complicated because it depends on the nature of the claim, but it's laid out in detail exactly what we have to have. And if you don't have what that settlement agreement says that we got to have, we don't pay the claim. We will not pay a fraud claim. We will not pay a claim that doesn't meet the requirements of the settlement agreement. If you have what that settlement agreement says that you're supposed to have and you meet the test as specified by the settlement agreement, we're obliged to pay the claim, and that's what we have been doing since day one.
Mm-hmm. Just to add to that, and again, I'm an attorney who represents people with business claims. Certainly you can do it without an attorney, but qualified attorney with qualified CPAs, tax experts, they may be in a better position to help you supersize the value of your claim, because if you can prove your losses are greater than you realize they were, just like a tax preparer or a CPA might do a better job at saving you money on your tax returns. So again, the better prepared you are doing it yourself or with expert help, the better the outcome may be. And when you say you don't pay fraud claims, it's not a fraud if you're not sure if your losses are due to oil spill or not. That's not what you're talking about, right?
Let me define fraud for you. Fraud is a claim that someone submitted false documents, someone has submitted made assertions that are not correct based on what they say their tax returns are, or what they say their statements are, or what the nature of their business are. Misrepresentations is fraud. Mm-hmm. If you meet the test that's specified in this settlement agreement, there's nothing fraudulent about that. I mean, they tell you what to file. If you file what they have and you have what they have, that's not a fraudulent claim.
How many claims do you process a week?
Well, we've gotten to date over 204,000 claims we've received. And we continue to receive claims every day.
Yeah, okay. And claims are still being paid even though this appeals process is going on.
I'm sorry.
Yes, it's Gulf-wide, and we continue. We've never stopped.
Never stopped. Okay.
We've never stopped since June 4 of last year. We were ordered by the court to open a door, which we did. We've been paying claims at a record pace here. There's been a lot of issues, a lot of things we've had to deal with. But I checked this morning. We have sent out eligibility notices from June 4 through now of $4.6 billion. So there's a lot happened.
A lot.
And there's still a lot of work left for us to do. But obviously a lot has happened during this period of time.
Right, okay, and you have turned down a lot of claims, correct?
Yeah, that's kind of the unknown story here. Yeah. There have been literally thousands of claims that we rejected. They don't meet the eligibility requirements under this settlement agreement, or they signed a prior Gulf Coast release. There are a multitude of reasons of excluded industries, this agreement, but there are literally thousands of claims that we have rejected in this amount. And if you meet it, we pay it. If you don't meet it, we don't pay it.
Okay, all right, we have a question from Michael. Michael says, I'm unsure which 3-month period to choose as my period of loss. Should I choose the period which had the worst losses, or is that unfair?
Well, it's not for me to make that determination. It's to use the selection of the month that you figure best represent your chance of recovery in this case. I guess that's a simple way to put it. And
a little background, basically per the rules, and I don't want to oversimplify things, but you are allowed to choose a 3-month period just in the year prior to the time of the spill to compare against a 3-month period or quarter after the time of the spill, and if you can demonstrate a financial dip or loss after the spill compared to that 3-month period before. So logic says if you can show a 3-month period where you made more money before the spill and compare it to a 3-month period after the spill, I don't think there's anything unfair about applying the settlement in the way that most benefits you. I don't think BP, who made, I think, $11 billion the first quarter of this year, is going to be scrimping too much on executive bonuses if you use the settlement to your best advantage. BP did the settlement agreement, after vetting that agreement with hundreds of lawyers and accounting firms, I think they knew what they were getting into, and they avoided that punitive settlement agreement, which is what my understanding is. So we're going to talk about that on another episode.
Yeah, well, what we clearly do, the only thing I do is implement what's written. Yeah. And if you meet that test, we pay. If you don't meet the test, we don't pay.
It's another good reason to consult, do your research online, consult with an attorney. The attorneys will consult with you for free. You don't have to sign up with them. But get your information, make an educated decision.
Let's try to get in one more question here, because believe it or not, we are coming down to almost a minute, less than a minute here. We've got a question from Sam. I know, it's going by really fast. Sam says, my claim was denied by the GCCF. That's the Gulf Coast Claims Facility that was in place before, that was overseen by Ken Feinberg. Should I bother filing it again?
Just because you were denied by the Gulf Coast Claim Facility does not mean you will be denied in this program. You may or may not, depending what the requirements are. We have literally handled thousands of claims that were denied in the Gulf Coast Claim Facility because of these class-wide definitions and so forth I'm telling you about, that are now eligible in this case. So, if a person has a question about that, they certainly have a right to file and have that determination made.
And what would you say to Eric, who's probably in a situation like so many other people, who says that he had poor accounting practices during that period of hardship, and he wants to know, if he doesn't have any monthly financial statements, what should he do? Should he hire an accountant? What if he can't afford one? Very quickly, we have less than 60 seconds.
Well, we do our best to take the records that are assembled by the people and see if we can assemble the records that we have. But there's some basic requirements we have got to have. And if you don't meet those, we're not going to pay this claim. But it says in the settlement, it's claimant friendly. We try to assist people in the assemblage of the necessary documentation to qualify.
And see an attorney if it looks like you don't have what you need. Maybe that attorney can help you with an accountant or something.
We are completely out of time. Thank you so very much for being on the show. It's been a pleasure having you here. That is all we have for this week on Power of Attorney. Thank you for joining us. And remember, we always welcome your questions for our guests, and we want you to keep them coming. So you can send those questions to us through Facebook, through Twitter, and through email.
Be sure to visit our website at johnredmanpoa.com, and you can find more information and links to everything on today's show and past episodes. Thanks for watching. We'll see you next time.
Did that go by fast?